Have you ever wondered what happens when an absolute fundamental right to practice your religion collides literally head on with a child's constitutional right to be protected? Well, let's dive into this explainer. Today, we're unpacking a truly landmark judgment from the Constitutional Court of South Africa. It's this fascinating legal collision, really, a story of deeply held faith, the transformative power of a brand new democracy, and the incredibly complex challenge of balancing the competing rights that define exactly how we live in a modern free society. To map out how the court navigated this, here is our agenda. We'll start with the blanket ban, move into the religious freedom argument, examine protecting the child, navigate the balancing act, and finally arrive at the final verdict. Okay, part one. The blanket ban. So our journey actually begins back in 1996. This was a massive, pivotal moment in South Africa's transition to a new democracy. The entire legal system was basically being rebuilt from the ground up, and one result of that was the South African Schools Act. The wording of this act was just absolute. The state enacted a complete blanket ban on physical discipline in all educational institutions across the board. No caveats, no exceptions, no gray areas whatsoever. The state was making a definitive statement. Corporal punishment in schools was officially a thing of the past. But, as you might expect, this absolute ban was quickly met with massive resistance. An umbrella body called Christian Education South Africa, which represented 196 independent schools and roughly 14,500 students, pushed back hard. They took their case straight to the courts, arguing that this blanket prohibition actively violated their constitutional rights to freely practice their religion and, crucially, to fulfill their parental duties. Which brings us to part two, the religious freedom argument. To really understand this conflict, we have to look closely at the parent side. They cited specific biblical verses, like Proverbs 23:13. To this community, physical discipline wasn't violence, not at all. It was what they termed corporal correction. They viewed it as a divinely imposed responsibility, an essential act of love that was specifically designed to build character and ultimately save a child's soul. And their core argument goes even deeper. They pointed to a scriptural mandate to raise their children in a very specific way. You see, they weren't just dropping their kids off at school. They felt they were actively delegating divine authority to the teachers. By signing a formal consent document, parents were legally and spiritually making the school an extension of their own family's religious life. Now, a really important detail here. This wasn't about spontaneous anger or a teacher just lashing out in a moment of frustration. Actually, scratch that. It was the exact opposite. It was a meticulously planned, highly institutionalized procedure. There were strict requirements involved. They had to get a witness, identify the specific biblical principle that was violated, and then end the whole process with a mandate to pray with and hug the child. This incredibly structured approach really highlights just how deeply integrated and formal this practice was within their specific religious ethos. All right, let's flip the coin. Part 3, protecting the child. The state countered all of this by pointing directly to the Bill of Rights. They argued that physical punishment, regardless of a parent's intentions, violates a whole host of absolute guarantees. We're talking about the right to equality before the law, respect for human dignity, freedom and security of the person, and, most notably, a child's specific protection from maltreatment and degradation. The historical context here is absolutely vital. The state argued that South Africa had suffered a massive surfeit of violence in its past, a past heavily characterized by state-sanctioned physical assaults and rampant institutional abuse. To truly break away from that dark history, the new constitutional order had to be fundamentally different. It had to align with peaceful international human rights treaties like the UN Convention on the Rights of the Child, which strictly demands the complete abolition of violence in schools. It's fascinating to listen to the stark juxtaposition in the language being used by both sides. It really reveals the core of the conflict. The parents use words rooted in love, correction, and divine duty. Meanwhile, the state's vocabulary is firmly rooted in the stark legal language of assault, violence, and abuse. We have two completely different ways of perceiving the exact same physical act. So how do you resolve that? Part 4, the balancing act. To untangle this knot, Judge Sachs relied on Section 36 of the Constitution, which is known as the Limitations Clause. Now, this isn't some rigid mechanical checklist. Instead, it requires a proportionality test. Basically, it's a very delicate balancing act. The court had to weigh how important the religious right being limited is against how important the law is that's actually doing the limiting. And Judge Sachs openly acknowledged an intense conceptual difficulty here. I mean, think about it. How do you weigh the existential against the secular? How do you possibly balance unquestionable faith and a community's core identity against the state's pragmatic goal of reducing systemic violence? It's like trying to compare apples and, well, completely different universes. They belong to entirely different worlds. He also pointed out the incredibly complex emotional reality of the situation. We must not doubt the parents' spiritual sincerity. They genuinely feel their dignity and religious rights are being restricted by this ban. However, the court just couldn't ignore the environment where the punishment actually happens. The institutional, somewhat detached nature of a school is entirely different from the intimate, spontaneous environment of a family home. The act of an adult teacher striking a child with a cane in a school setting intrinsically carries a real element of indignity. Which leads us right to part 5, the final verdict. Judge Sachs's words in the ruling perfectly captured the true heart of the decision. He stated that the ban wasn't just some administrative or pragmatic rule to keep order in the classroom. No, it was a deliberate, transformative, and highly symbolic break from an authoritarian past. It was designed to teach the next generation of citizens to solve problems through reason and dialogue, rather than through physical force. So ultimately, the court ruled that allowing religious exemptions, even for such a sincere and highly structured community, would severely undermine the state's paramount duty to protect its people, especially children, from violence. The appeal was officially dismissed. The blanket ban remained completely intact for all schools, public and independent alike. The court's reasoning was essentially this: parents are still completely free to raise their children with a Christian ethos and belief system. The only thing they are prevented from doing is authorizing teachers to use physical force on school property. But we're going to leave you with a rather provocative postscript today, one that came directly from Judge Sachs at the very end of his judgment. Throughout this immense, high-stakes legal battle between the state and the parents over the rights of the child, the actual subjects of this punishment, the students themselves, were never legally represented. No one was ever appointed to speak for them. They were never asked for their opinion, their personal experiences, or their feelings on the matter during this entire landmark constitutional debate. It leaves us to wonder, in debates about protecting the vulnerable, how often do we actually stop to listen to the voices of the people we are arguing over?